Good morning, everyone. The 36th District Court in the state of Michigan is now in session with the Honorable Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any materials. Please keep your device on mute until the judge addresses you.
All right, good morning to all. This is case number 21-169-823. This is Dr. Harris, Burkill, Wang, Sarge, and Associates PC versus Eric Abbott. The matter is before the court. Set on today for hearing on a motion to set aside a default judgment. Your appearance for the plaintiff in regard to this matter. I have Mr. Abbott on the Zoom. Say something if you're here. Looks like this was set under the 534 number, so we might want to check and see if there's stuff there. Okay. All right, so I'll recall that. All right, the court now calls case number 22243399. This is Roderick Skipper versus Victor Rogers. The matter is before the court, set on for regarding a motion to set aside a default judgment. The record should reflect that a judgment was entered in this matter on the 30th of November 2022. Looks like the total amount of the judgment is $4,000. All right, so do I have Roderick Skipper on this Zoom? Mr. Skipper, say something to me. Good morning to you.
Good morning, sir.
All right. Now I'm looking for Victor Rogers. Mr. Rogers. Victor Rogers, say something to me this morning.
Yes, sir. Victor Rogers here.
All right. Thank you, Mr. Rogers. All right. So I did receive the motion, an affidavit to set aside the default judgment in this matter. I'm looking now at the file. I granted the motion and set aside the default and then set the matter on for hearing on today's date. All right, so what's the issue here, Mr. Skipper? Why are you suing regarding this matter, sir?
Because Mr. Rogers has sold me a deed that he never registered, which prevented me from registering the deed when I purchased the property from him.
All right. So you paid some money for a piece of real property and you could not register it when you tried to. Is that correct, sir?
Yes, sir.
But you were given the deed by Mr. Rogers. Is that correct?
Yes, sir.
And you're saying that deed could not be filed with the Register of Deeds office. Is that correct?
Yes, sir.
All right. So what gives Mr. Rogers here?
What was that question?
Yeah, it wasn't a real polished one. I said, what gives? What did you get? A quick claim from someone?
Right, from a real estate company that owned the property. It was over a year ago when he received it. He didn't pay the taxes on the property, is why it went into foreclosure. He had over a year to do it. But if he had took the quick claim deed that I had and tried to register it and had a problem, all he had to do was reach out to me and it could have been straightened out. But he didn't do it. He didn't pay taxes on it and the property was foreclosed.
All right, I do see a notice of foreclosure. Looks like that happened from the order that I'm seeing. That was in 2017. When did you give a deed to Mr. Skipper?
I don't know the exact date right now, but it was over a year after he received the property from me.
All right, let me see what's going on here. So it looks like what I'm seeing here, I'm seeing a quick claim from Heritage to Mr. Victor Rogers, and it looks like the date of that quitclaim is January of 2021. Would that be about correct? When you received the property, Mr. Rogers?
Yes,
All right, so it looks like to me that the property was already in foreclosure even at the time that you received it.
I wasn't aware of it. And
Well,
I
at least
have the owner of that company phone number and everything.
All right. Did you ever file that quitclaim deed with the Register of Deeds office?
No, I didn't.
Yeah. All right, so I'm looking here, and I see that the quitclaim deed, I'm looking at. Just one moment, just looking through some of the stuff that was submitted to me. Okay, so actually what I see is that the Wayne County Treasurer's Office did quitclaim the property to Heritage, and that was in 2018. So that foreclosure from 2018 or 2017 that I was seeing, Heritage purchased the property out of foreclosure and then sold it to you. So, Mr. Skipper, what are you, what problem are you running into when you are trying to register this?
When I had bought the deed from it, we had ran down to the city county
Sure.
building. Yes, sir.
Yes.
And we've been down there several times, but by the property was not in Mr. Rogers' name. They refused to give us any kind of knowledge or any kind of information what's going on with the property because they said we're not affiliated with the property. But after us been going down there so many times and we was pleading with these people, I mean, we just don't know what to do at this point. Because when I talked to Mr. Rogers, he said, well, all I can tell you is I got the deed. I don't know what's going on. I did my part pretty much. You do your part. He pretty much refused to help me. So at this point, we had to figure out. The lady just pulled us to the side. She said, well, listen here. Mr. Rogers never registered the deed. For that reason, your deed is no good. She told me at that point, and that was just out of her being more than kind to us. At this point, everything is going down as far as like the house going to foreclosure. And I even told Mr. Rogers, I say, sir, I had bought this property from you almost a year ago. It shouldn't even be going into foreclosure. It takes 2 years. That means you haven't even paid the taxes on this place, which he guaranteed me the taxes was paid up at that point that I had bought it. It was a very difficult situation because I have known Mr. Rogers for years and I trusted that, you know, what he told me was true. But once I found out he never registered the deed, it was nothing that I can do with any of the paperwork that I had because it was no good.
All right, got you. All right, I'm going to come back to you guys in just a moment, so just stand tight, and I'll come back to you, Madam, in just a moment. All right, this is case number 22-243449. This is Azara Stohan versus Dolls Roofing and Construction LLC. Do I have the plaintiff in this matter say something to me?
Yes, good morning, Your Honor.
All right, what is your name?
Azara Stolhand.
All right, thank you, Ms. Stohan, and good morning to you. All right, looks like this is an appeal from the Small Claims Division of this court. Do I have Dow Roofing and Construction on this Zoom? Somebody from Dow Roofing and Construction? Let's see. Just one moment. Let's see. So, ma'am, what Zoom number did you get when this was mailed out to you, ma'am?
I didn't get one. It said to appear in person, but when I called, I was hoping to adjourn this for a later date. because I've been in and out of town taking care of my father in another state. But they said it was virtual, so I didn't get any of the information on the actual ticket. She just gave me the Zoom number.
Right, I think the Zoom number, I think the incorrect Zoom number went out to the other side of this. So when did when did you want to, you indicated that you wanted the court to adjourn this and set it for another date. Is that what you wanted?
I do have all of the documentation available if that's, because I do have a new bid from another contractor and such stating that the work that was performed needs to be torn off and completely redone. And that's what I was missing in the small claims court. So I don't know if I'm more than happy to email everything, but if I have to drop them off physically, I would have to adjourn.
So let me do this. I'm going to adjourn the matter. All right, so and looking at this, it seems to me that the last time that you came before the court, the defendant, Dow Roofing and Construction, nobody appeared from that company. Is that correct?
Correct. They haven't showed it either one.
So now, the property where they did this work is in Warren, is that correct?
No, it's in Wayne County. It's in Detroit. I live in Warren.
Yeah, what's the location of the property where work was done?
It is 3941 Fairview Street.
Okay. Just one moment. Did you? Did you? Okay. I think I see what I'm looking. All right. So when you filed the complaint, you didn't put on the complaint that which will establish jurisdiction, but I do see in the paperwork that the contract that you submitted to the court references the Fairview address, because when you file a complaint with the court and you put in that complaint an address of Warren in a roofing company in Allen Park and you're suing in Detroit, you have to specify that this has something to do with Detroit. Otherwise, that would typically get your case dismissed. But I do see that you have, subsequent to that time, that you presented the contract that shows that the work was done on property in Detroit. All right. So, ma'am, what do you have? Tell me a bit about this property. Let me swear you in, and then let me have you tell me a bit about this property. Raise your right hand and be sworn this time. You do solemnly swear or affirm that the testimony you're about to give is the truth, nothing but the truth, so help you God.
I do.
All right, and state your name again for the record, if you will, ma'am.
Azara Stolhand.
All right, thank you. And again, I'm calling out for any persons connected to Dow Roofing and Construction LLC. If you're on the Zoom anywhere, please say something at this time. All right, this matter is set on for 10 o'clock a.m. It is now 10:25 a.m. So, ma'am, you hired a company to perform some roofing services at property on Fairview Street in the city of Detroit. Is that correct, ma'am?
Correct.
All right, and that property location, based on the document that you submitted to the court, is at 3941 Fairview. Is that correct, ma'am?
That's correct.
All right, now with regard to the roofing repair that you hired services for, was this for a complete tear off, or did this involve adding another layer of shingles? What happened? Tell me a little bit about
Yeah, so originally it was going to be a tear off, and we had spoken with them and decided to actually add dormers. And when we had the work done, we had questions arise during, the construction process. And finally, the last day that they were on site, we brought up some major concerns. Things were not finished properly. And granted, I'm no contractor, and so all that we had asked was that we wanted to bring in another contractor just to make sure that everything was correct. And they gave the keys back, they walked off the job, and we couldn't really get anywhere after that. So the quality of work, it all has to be torn down.
All right. So how much money was paid for the work that was done?
A total of 9,000, but there were still some shingles and some materials left over that they had not used. And with small claims, we know that the max is 6,500. So that was what we went with.
All right. So at the point that problems arose, the contractor indicated to you that they had completed what they were hired to do. Is that correct?
Correct. Or they said that they had about one more day left.
Right. How many days were they there on that job?
They were there for about 2 weeks.
Right. Was there any were there any persons brought out to inspect or any of the work that was done as work was being done?
No. In regards to like the city, do you mean?
Well, no. Did you hire another company or anybody that came out and took a look at the work as the work was being done?
No, not because we wanted to give them a chance. They kept saying, no, don't worry about it. It'll all come together once we're finished. But then by the day before they were finished, the roof was shingled. And there's like an exterior wall that doesn't connect to the main home. I mean, you can shake it and it like the whole thing shakes. And so that's when the major concerns arose.
When you said exterior wall, talk to me about that, please.
Yeah, so they were framing in the dormers, and so the pitch of there was still like one existing room, because that one was still in good condition. And so we were going to build the dormers from that wall, and the wall that was connecting to the existing roof line, it was not actually connected. And I did submit photos. I don't know if you have access to those or not, but it wasn't connected at all.
All right, and the issue relative to the dormers, that issue came up after the work had commenced. Is that correct, ma'am?
Do you mean that we had decided to do the dormers, or the issues arose?
It sounds like to me, I'm asking you specifically, it sounds like to me that the issue with regard to the dormers is something that came up while the work was in progress, correct?
Correct.
And that constituted a change. It looks like something was written in on a contractual document in that regard. Is that correct?
No, we had done the contract before the work was started to add the dormers, because initially it was just a tear off, but we were trying to maximize the square footage because of the roof line. And they had agreed that that was a good idea and that they could take on that job.
All right, go ahead. Tell me anything else you want to bring to my attention regarding this matter.
This just goes, I guess, towards character. But the first day initially, there was already crew members that were like screaming at each other. It brought out some of the neighbors. The neighbors were concerned. They even pointed the cameras towards the house just so that they could kind of keep an eye on everything while we weren't there. From day one, there were issues, but we were trying to give them a chance.
And so it looks like this contract said that half of the payment was made, and then at the conclusion, the final part of the payment was made. Tell me what happened.
Yeah, so we had initially put down the deposit and we had asked for a receipt multiple times. I have screenshots of text messages asking for the receipt that I submitted, but we never did receive any sort of paper receipt or digital receipt to actually confirm that the payment was made. So all we have is our withdrawal slips and stating that the half of the deposit or the deposit was made. And then we had paid about $3,000 more for materials and such. And then the additional $3,000 would have been due at the finish of the job.
All right, so when all was said and done, it was gonna be 10,500, if that other 3,000 had been paid, correct?
Correct. And then there were additional costs for materials that were not in the contract, which is why we were only agreeing to the 6,500.
Okay, now, so what it looks like to me is the initial payment, the initial down payment was $4,500, correct?
Correct.
And then there was $3,000 spent in materials, is that correct?
Correct.
You're saying that there was some additional amount spent on materials?
Yeah, but that was not in the additional contract because of they didn't measure correctly. So yeah.
Got it. All right, so 7,500 is the amount that was actually paid, is that correct?
Correct.
So now tell me about this subsequent contractor that you have brought in and their thoughts about what they'd like to do and what that's going to cost you. Talk.
The overall bid ended up being over $47,000 for the tear off and then reconstruction of doing it correctly. And of course, that did have additional aspects to the bid that this one did not include. But it's clearly states on the bid that everything has to be torn off and that really none of it is usable.
Well, and of course, you get another contractor to come in and they typically want to start fresh.
Yeah.
That's, that doesn't enter to the person that did the previous work. But so when you say $47,000, is that just the roofing and dormer work, or is that some other work? The overall
No,
package?
Like I said, it does include additional work as well. So but the portion of the bid that is for the roof and such, that is it clearly states that none of it is up to even code. I mean, none of it is even structurally sound.
Wow.
Yeah, I mean, there's no way that I would feel comfortable putting a family in there. And that's really the bottom line. The money is one thing, but if something were to happen, I mean, yeah, this isn't even livable. I mean, we have to have everything torn off and redone before anyone can even think about, it being habitable.
So how much is it costing to redo the roof out of that $47,000?
It is, I would have to pull up the bid. Is there a way that I could send that to you by chance?
Yeah, do you know how to screen share it now?
Yeah. Hang on,
Do you have it on a digital device?
It's on my phone, which I'm on my laptop, so I would have to, yeah.
Yeah, you should be able to screen share it that way.
Okay, bear with me.
You having any success there?
Yeah, so I'm pulling it up right now. It's loading. Okay, so for the so it just has the total for all of it. I don't know if you still would like to see it or not.
It does not segregate any amounts as it relates to the roof. It just gives an overall project amount. Is that correct?
Correct, yeah, and then it breaks down like the payment schedule, but it doesn't have just for roofing. Like it has 10,000 when shingles are installed, you know, etc.
All right. Now you said that you had some photographs that depict the condition of the roof after the completion of the work. Is that correct?
Correct. I had submitted them to the court previously. I'm not sure if you have access to those, but I do have access to those as well.
Let me take a look here. I see a number of photographs that tend to show wood framing, and then also what looks like underlayment, that is the laying of wood to cover an open surface. So with this being a tear off, is that in fact what a part of what occurred? Is that underlayment or a new wood was placed over the roofing area?
Correct.
I also see a photograph depicting a back porch roof that has new wood or new underlayment and has paper on top, and indicates that porch is unfinished. Correct? I'm looking at a front porch that seems to be shingle, and there's a pointing out that the front porch connecting roof line flashing, that the flashing is insecure.
Correct.
All right, ma'am. Anything else you'd like to tell me at this time?
I did find that video of that wall, the exterior wall, if you'd like me to screen share so that you can see that.
Yeah, go ahead, ma'am. If you can screen share that.
Okay.
All right, and so what is it that, and what does this depict? Tell me about it. I'm able to see it. So tell me what this depicts.
So this is that exterior wall that's not actually connected to the existing roof line. And I mean, this was, to them, it was finished. I mean, there's a huge gap where you can see the sky. I mean, it's it's almost, it's hard to even look at because this has been so difficult to like express really like in pictures without seeing it in person. what it really looks like and like the gravity of this. You know, does that make sense?
Yeah, I got you. What area of the property does this area cover?
This would be, so this is where they added the dormers. It would be over the kitchen area.
And was this an area that was completely covered by a roof prior to the commencement of work?
Yes.
So,
That the initial, that peak, the like weird triangle roof line, that was what the entire roof line was. And so that's why we wanted to come in and add some dormers and to maximize the space. But if we would have known what would have happened, we would have just done a tear off and kept the original roof line.
all right, thank you. Anything else you want to bring to my attention this time? You can.
No, that was it. Thank you, Your Honor.
All right. All right, so the court has listened to the testimony offered in this matter, has reviewed the contract that the parties entered into, and is apprised as to the financial exchange that occurred herein. It looks like there was some $7,500 that was paid, and that the job upon completion would have yielded some $10,500. And there does appear to be a subsequent plan for construction that is in the nature of $47,000. The court does not have a basis to disaggregate from that contract or from that proposal amounts that it might take to bring correction with respect to the roofing that is involved herein. There is no expert that has been able to testify here. Ms. Stohan is not an expert at roofing. Apparently, the company that was hired is the one that bears the expertise in this regard, and the subsequent company will likewise bear some expertise, but they're not here to provide any testimony in that regard. And the document itself that involves other work does not disaggregate in such a way that the court could determine exactly what problems the proposal has made engage, and whether or not those problems are supported by any evidentiary presentation. What has been presented is that there are some problems with the roofing condition, the roof as constructed. That seems pretty intuitive based upon some pictures that were presented to the court. The court is unable to find that this requires reconstruction, and I don't have an expert to tell me that. And when there was persons on the scene that performed work over a significant period of time without interruption, without professionals coming in, or inspector or someone coming in and giving a review and an assessment as to what was going on, either interim or at the end, then the court can't really know whether or not this is a situation that requires reconstruction, or if that is indeed just the desired approach of the new proposed contract. And it makes sense that if someone is coming in new to do the work, that they don't want to work behind someone else. They like to start fresh. They like to make all of the work their own work and do it to their own specifications. That makes sense. The question becomes whether or not Dow's roofing and construction was negligent in the performance of the work they did to any degree. That's the real question, not whether or not they were so negligent that it has to be reconstructed. The question is whether they were negligent. When I see a porch area that has underlayment, but has work that has not been when I see an area of the roofing where the flashing is insecure, it looks like the shingles may not be properly aligned in that area as well, as the court took a view of the various photographs that were submitted to the court. And then when I look at an area where there is a gap between the roof and the downward wall, obviously there is something that is unfinished about that. While there is unfinished payment as well in the nature of $3,000. So all of those kind of concerns are what the court takes into consideration. So where this is a contract that involved $10,500 and where the defendants did not complete the work in a workmanship manner, and where the defendant, I should say, left obvious conditions that does not require expert opinion. That is, there is an opening that remains at the edge of the roof that does not connect to a downward wall. There is also there are also flashings that are not properly attached that is obvious to the eye of an untrained expert. And there is an area of the roofing that was simply not covered. There was underlayment, but the roof was never covered. That portion of the roof was never finished. My determination in this matter is that where there is a contract for $10,500 and where the defendants failed to complete the work on the contract, and where all of the contract was not paid, that there is some lost value in regard to the intention of the parties here, and that the plaintiff did not receive the full value what they purchased, and that the court is going to determine that 50% of the work was done in a workmanship-like fashion. That may still have to be redone, but the defendants accomplished what appears to be roughly 50% satisfaction. Therefore, I will order that half of the funds under the contract be repaid. That will be in the nature of $5,250. $5,250. I'll find that given that the work was not done in a complete workmanship manner, that there were conditions that existed that are obvious. While the court does not have an expert, the conditions that were shown to the court concerning the ones that I've already expressed would indicate that the work was done in a less than workmanship manner and that the work was not, in fact, completed. For that reason, judgment is granted to the plaintiff in the sum of $5,250 together with the filing fees and service fee in that matter. That will be the court's judgment. So, ma'am, I will prepare a judgment will be sent out. So let me ask you how much did you pay in filing fees to file this? Recall?
And sorry?
How much did you pay as a filing fee to file this report?
Oh, it wasn't much. I believe it was, gosh, maybe $50 total, I believe. I can't remember, to be honest.
Okay. And I see a certified mail fee of $13, correct?
Correct.
All right. So we'll include that in the judgment, and you'll get a copy of in the mail in the next few days. All right.
Wonderful. Thank you. Thank you, Your Honor. Have a great day.
All right, we're back on the record regarding Skipper versus Rogers. All right, so gentlemen, obviously the problem here is that if Mr. Rogers is not able to effectuate a result and get the money, or strike that, get the title to the property, then he's entitled to his money back. And this is not anything that's difficult. This sounds like the problem here has to do with Mr. Skipper not ever submitting a deed to the Register of Deeds office. If Mr. Skipper does not file his deed with the Register of Deeds office, then obviously Mr. Rogers cannot file his deed. because it will show no track title. Other words, what could happen is that any person could show up at the Register of Deeds office with a quick claim deed and file it. But what the Register of Deeds office does is they look to see whether or not there's a continuity of ownership. What did the last deed? What did the last deed do? Is there a tracking of who owns the property? Without that, there is no way that Mr. Rogers could in fact file the quick claim deed with the Register of Deeds office. So
Your Honor, with all due respect, I think you have it backwards.
Well, if I have it backwards, I have the names backwards. So Mr. Skipper, obviously, you're the one that have not been able to file that deed because Mr. Rogers did not submit a deed to the Register of Deeds office. I mean, that's a simple proposition. Typically, what happens in these situations is that both parties go to the Register of Deeds office. Mr. Rogers files his deed, and right behind that, Mr. Skipper files his deed. But if the Register of Deeds office does not have any evidence that Mr. Rogers has title, of course they're not going to accept Mr. Skipper's deed, because there's nothing there at the Register of Deeds office to show that Mr. Rogers ever had any title. You can't give a person a quick claim deed to file and perfect their interest, and they not be able to perfect their interest, and then say, well, it's their fault that they can't perfect their interest. If you never filed a deed showing your interest, of course they'll never be able to show their interest. It can't happen, right? So in this situation, it seems to me, unless somebody can tell me something different from those set of facts, that Mr. Skipper is entitled to specific performance, which means that Mr. Rogers put up a deed to the Register of Deeds office so that Mr. Skipper can perfect his interest, or that Mr. Rogers refund Mr. Skipper his money. That's what this case looks like. So talk to me, gentlemen. Anything else anybody want to bring to my attention at this time?
Judge Coleman, this is Mrs. Good morning. This is Mrs. Rogers. It's just a few things that I would like to state.
What's your name, Mrs. Rogers?
Mrs. Rogers, first name
No.
Carmen.
That's not your name. What's your name now?
Carmen Rogers.
All right, thank you, Miss Carmen Rogers. All right, good morning.
Okay. It was just a few things that I wanted to mention. The first being that Mr. Skipper has stated that he had went down to the city and he had asked Victor, and Victor went with him. That never did transpire. Had I known that this was an issue, had we known, because we never received any communication until after it went in foreclosure. One of my sorors is over that department. I would have intervened and had her to look at everything and try to help to resolve the issue. Once we were told that the property had been in foreclosure, we received a phone call from Mr. Skipper's girlfriend. She called us early in the morning, very irate, very demanding, and very threatening. And I had said to my husband at that time, if she calls again in that type of tone and that behavior, I was going to go to the police and file, report. So it was like, I didn't know who she was. She said she was his girlfriend and she was dealing with the issue. So again, as I stated, had I known that this was an issue, we could have went down there. I could have talked to Ebony and Ebony would have resolved the issue, but we didn't know until after everything went in foreclosure. And it was over a year. Now, when the property was sold to Mr. Skipper, at that time, maybe Mr. Skipper, maybe Mr. Rogers should have said, well, hey, let's go down there and do what we need to do, But that wasn't done. But I think he waited until it went in foreclosure. So I don't know if he received any notices from the city. I don't know. Did he not look at the foreclosure notice, or did he not look at the correspondence saying that, hey, if you don't pay this by this date, it's going to be in foreclosure, which is what they send you, you know. So I just wanted to add that for the record, you know.
Well, that's valuable. That's valuable information, and in a moment, I am going to have the parties to reiterate just under oath the things that they've said. I've kind of dealt with this and looking at it kind of in a mediated kind of way. Here is the problem. The biggest problem here is that Mr. Rogers never filed that deed with the Register of Deeds office. It doesn't matter when Mr. Skipper goes there or doesn't go there. Or
Exactly.
Let me finish now. Okay, no interruptions. Doesn't matter when he goes or doesn't go. If he sits around and lets the property go into foreclosure and loses it that way, that's his problem. The problem here is that Mr. Rogers never submitted the deed to the Register of Deeds office, because if Mr. Rogers filed his deed, then his perfecting his interest such that Mr. Skipper would be required to act would have occurred. So that Mr. Skipper, he could wait years to go and file his deed if he wants to. He could fail to pay taxes and so on and so forth and lose the property. But the issue is whether or not he could have perfected his interest in this property. It is whether Mr. Skipper could have perfected his interest. And given that Mr. Rogers never filed the quitclaim deed with the Register of Deeds office, there's no way that Mr. Skipper could perfect his interest. Whether he went the day after, a year after, or 2 years, or 5 years down the line, he would never be able to perfect his interest because there is no continuity of ownership. And the only way that there would be that is if Mr. Rogers had filed his quitclaim deed with the Register of Deeds office. Then even if he did that after he sold it to Mr. Skipper, as long as he filed that quitclaim deed before Mr. Skipper went to the Register of Deeds office, then Mr. Rogers had fulfilled his obligation. It doesn't matter if Mr. Skipper sits around and the tax agency takes it, tough luck. But Mr. Rogers remains in this because he did not file a deed with the Register of Deeds office. So he cannot take Mr. Skipper's money. He cannot keep his money because Mr. Skipper never was able to perfect his interest at the Register of Deeds office. Again, I'm repeating myself because Mr. Rogers never filed it.
Okay.
That's the case in a nutshell. I mean, that's and I guess, and you know, we can't really get into that as such, but I'm wondering why, especially if you're selling the property, why not just go and file the deed down and get that out of the way? Because it seems like this was not a trick situation. There is no evidence here that Mr. Victor sold the property to 5 people or anything. There's no trick involved. This is an arm's length deal where you know, he sells it to Mr. Skipper. Mr. Skipper gets the deed, and everything is good. But if you don't file that deed with the Register of Deeds office, then Mr. Skipper will never be able to file his. Can't. And I think everybody here knows that. That's intuitive. When you purchase a property or anything else, you get a deed. Of course, in those situations, where there's a mortgage, oftentimes there's a warranty deed. And that warranty deed is for these reasons. Warranty deed is a deed that guarantees that there are no encumbrances, guarantees that there is a consistency of title. That's why you hear the difference between a warranty deed and a quitclaim deed. A quitclaim deed, there's no warranties given with that, except for the person saying that I give you the interest that I have, and the interest that I have has been perfected by the record. So when you go down there, whatever interest I have, you have a quitclaim deed now saying that the interest that Mr. Rogers had is the interest that Mr. Skipper now has. Well, when Mr. Skipper goes to the Register of Deeds office saying that I have the interest that Mr. Rogers had, the Register of Deeds office will say, we don't see a record of Mr. Rogers having any interest. That's a problem. So, Mr. Skipper, are you able to come on the screen, sir?
Yes, sir.
Right, so turn your camera on. Let me see you if you can. All right, raise your right hand to be sworn, sir. You do solemnly swear or affirm that the statements that you made to the court regarding purchasing this property and the efforts that you made to submit it to the Register of Deeds office, that is the truth? So
Yes, sir.
God,
Yes, sir.
you were not able to file it with the Register of Deeds office, is that correct?
Yes, sir.
You paid $4,000 for Mr. Rogers to sign that deed over to you?
No, I didn't pay 4,000 for him. That's the money, partial of the money that I'm out of. I gave Mr. Rogers 1,700 for the actual property.
Okay. And
then I had a
Go
privacy fence put around the property. Then also got some items put on the property that will have to be paid to remove from the property. So that's what comes up to the $4,000.
All right. So why didn't you go to the Register of Deeds office to perfect your interest before investing money on the property?
Well, I did went before, but we couldn't get any information because the lady was saying, well, she didn't tell us anything. She pretty much just, told us there's nothing she can do because I couldn't prove I had any interest and the paperwork didn't appear right to her. But after her seeing us so many times, she just said, listen, I'm going to tell you, your deed is not right. The person that sold you the deed shouldn't have sold you this property. And, at this point, I'm confused. I didn't know. I called Mr. Rogers. He said, well, I don't know what to tell you. I got a deed. You see it's a deed. So it's pretty much, he won't give anything. He pretty much refused to help me. I mean, with all due respect to his wife, I never had a conversation with him. And Victor is very hard to talk to. He's very belittling at times. So at this point, me and him, it got kind of heated. And I told Mr. Victor, I said, well, Mr. Victor, since you don't want to give me my money, at this point, I just have to sue you. I refuse to argue with him, and he has my money in his hand and refused to give it back. So that's what the law, that's why it came to the suit part. We have had conversations before. That's why it got heated.
All right, sir. Well, I can't take into consideration what the specific words that may have been given to you or said to you by the clerk at the Register of Deeds office. But the fact of the matter is that they would not let you file that deed, correct?
Yes, sir.
All right, let me come to Mr. Rogers, Mr. Victor Rogers. Sir, are you able to come on the screen at this time? All right, thank you, Mr. Rogers. Mr. Rogers, raise your right hand and be sworn, sir. I can't see your hand and your side, please. You do solemnly swear or affirm that the testimony, or we need our wives, you do solemnly swear or affirm that the testimony you're about to give and have given is the truth, so help you God. Is that correct, sir? You're on mute now, so I need to hear you.
Yes, sir.
All right, thank you, Mr. Rogers. Now, Mr. Rogers, I thought that this was a $4,000 sale, but actually he says that the gentleman says, Mr. Skipper says he purchased the property for $1,700. Is that correct, sir?
Actually, it's less than that because it was a gate. When he got the property from me, I was putting a gate up, and part of that $1,700 was for the gate that was being put up that would go in between the lot and the property that he currently owns. And he mentioned about things that he put on the lot, which was over a year later. He put some commercial containers on a residential lot, which he got 4 of them there that definitely shouldn't be in a residential neighborhood, and especially not on a residential property. They're commercial shipping containers. So
there is no, I don't think that there's any intent to try and charge you for shipping containers or anything put on property. I don't think that he's raised that, but you're just pointing out that given that it's a residential area, that it shouldn't be there, right?
yes, but he did mention that his part of his cost is from putting those containers there or removing them, which he would definitely have to pay to have them removed, because he should have, I feel he should have found this information that we're on right now. If he had came to me when there was a problem, I would have gladly went downtown with him. But he didn't do that. He waited. And I know you said it didn't matter how long he waited, but it's just the fact that he called it fraud. He said, I fraudulently did something, which I was like, I didn't do anything wrong. I didn't understand that the realtor that gave me the property, because I owned the house on the other side, he gave me the property because I helped him out with some things, but I didn't realize that I needed to go down and register the lot. That I didn't realize I need to do that, or I would have did it. I wouldn't have just not did it and just left it the way it was. But I'm thinking that with that, and when I received that quit claim deed with my name on it, I thought he had to register it to even give it to me. I didn't understand otherwise, but I do understand now what's being said. But I just wanted to say that because I didn't have any malicious intent on when I sold. I wouldn't have sold him something that I thought it was something wrong with it. And I've been knowing this man for years. There's no way I would have did that. And I told him that also, that I wouldn't have just outright sold him something and I didn't own it. And when he said I didn't own it and it was fraud, I was like, I don't see how it's fraud. And I got the paperwork here saying that I own it, that it's in my name, a quit claim deed. So
that's it. Let me stop you for a moment. I mean, that's the part of this that I'm not getting, because clearly you received a quit claim deed that vested ownership in your hands, Mr. Robert. It's no
right from the realtor.
Yeah.
Right from the realtor that owned the property.
Yeah. Navarro or something, correct?
I got it right here. Let's see.
Yeah, Alarizo Navarro.
What's their name here?
I think that's Alarizo Navarro. All right, but anyway, I'm looking at that, and for the life of me, I mean, that was what was that was the document that needed to be recorded.
I thought it was recorded. What's this name right here? It's a LLC.
Heritage Walk Realty Detroit.
Yeah, Heritage.
Heritage Walk Realty Detroit.
All right.
That's who drafted it. The lounge I see.
Yeah, yes, exactly. I think I was looking at something else, but yeah, I mean, that's clearly a deed from Heritage to yourself.
Correct.
But what I'm looking at does not have any markings on it that would demonstrate a registration with the Wayne County Register of Deeds office. Now, that's just a copy that I have here in the file. It looks like somebody did, the copy that I have in the file doesn't have that stamp on it. This is what needed to be filed with the Register of Deeds office, because once you file that with the Register of Deeds office, then it's out of your hands. But you had a duty to do that, because Mr. Skipper, there's no way that he could take a deed in there, because it doesn't show any continuity. So when you receive the deed from the Heritage Walk Realty Detroit LLC, they had received their deed from the city of Detroit, from the Wayne County Register of Deeds office. They received their deed, And so their deed was registered, so the next person in interest was Heritage Walk. So Heritage Walk then gave you a deed, giving it to Mr. Rogers. And what Mr. Rogers had to do was then take it to the Register of Deeds to show that he's the next owner. Once he shows that he's the next owner, then anybody else that comes along would have to show how they got it from Rogers to the next person. And you probably effectuated a deed to Mr. Skipper. The problem is that Mr. Skipper can't do anything with that unless this deed to Mr. Rogers is already filed at the Wayne County Register of Deeds office. Because that's the only way that it was showing any continuity. All right, anything else you wanted to bring to my attention, Mr. Rogers?
Other than the fact that like I said again, if I had known that I needed to register it, I would have did it. And if he would have brought it to me after he got it, we could have resolved it then. Other than that, as a year went by, he's using the lot, putting all kind of equipment on it and everything. And now he comes and say, I sold him something I never owned. That's where the conflict came up right there. But I do understand the legal part that you just mentioned.
Yeah, well, you definitely own it. I mean, that's no question about it. But if it's not filed with the Register of Deeds office, man, that's a big problem. All right, thank you, Mr. Rogers. Ms. Rogers, can I see you on the screen? Ma'am, raise your right hand to be sworn, please. You do solemnly swear affirm that the testimony that you've given, the statements you made is the truth. So help you God, ma'am.
Yes.
All right, Ms. Rogers, anything else you wish to bring to my attention at this time, ma'am?
No, that is pretty much it. Again, I wish Mr. Skipper, and I don't know him, I've never had a chance to meet him. Had I had a chance to meet him, if I would have known, I could have intervened and I could have done something to mediate or to resolve the issue. But again, contact was not made until foreclosure.
All right, thank you very much, ma'am. Thank you very much. All right, I've listened to the testimony offered in this matter. I reviewed the evidence submitted to the court, and also I've been able to determine that the parties on both sides are telling the truth about what happened. This is one of the most interesting and unfortunate kind of situations that I've seen. I can understand why these long-term neighbors fell out about this. This was really not something that was a bespeak on you guys' relationship. This had to do with this paperwork. That's what this really was. This was a failure of paperwork, and the Register of Deeds office would have gladly accepted the deed because the paperwork that I'm able to see shows a continuity of title. It shows that a company transferred the title to Mr. Rogers. It shows that Mr. Rogers transferred the title to Mr. Skipper. But it shows also by way of the honest testimony of everybody involved. The honest testimony is that deed to Mr. Rogers was never filed with the Register of Deeds office. And that's the failure in this case. That's the problem. That's the sole problem here. There's no fraud. If there was, there is, but there's no fraud here. Mr. Rogers didn't register the deed that he had. He had a deed giving him the property. He simply didn't register. It's not fraud. It's negligence. It's a mistake that was made, and that mistake is costly to the parties that's involved in. In the first instance, Mr. Skipper is entitled to a refund of the $1,700 that was issued as a part of the deal. He also indicates that over the time that he relied upon ownership of the property, they spent an additional $2,300. The issue that the court has to look at in regard to the claim of the $2,300 is whether or not, number one, that has been proven, and then number two, whether or not the reliance upon the deed that was given was reasonable. So that when a person signs a deed giving up interest in property, it makes sense for a party to rely upon that document to the extent that the person that they received it from is to them, to the best of their knowledge, a reliable person. That creates a reliance that you don't have to get the deed registered right away. You could begin to operate on that property because that person that signed the deed is a reliable person. The question then becomes how far does reasonable reliance go? In this instance, Mr. Skipper indicated that he put a fence up and that he expended funds to do that. He also expended funds to put items on the property and maintenance of the property during the time that he was relying upon the deed. But somewhere along the line, Mr. Skipper knew or should have known that he could not get that deed registered. At the point that he knew or should have known that he could not get that deed registered, that's the point at which it stopped being reasonable to expend any money. Because if you haven't got that deed registered, once you find out that you can't get that deed registered, you can't do anything on that property that will be regarded as reasonable. Because now you know that I can't get my deed registered. That part is going to have to get taken care of before I spend any more money. So God forbid, we don't have this case here, but you go down and you try to get the deed registered, you can't get it registered, then you decide, well, I was going to build a garage on there, so let me go ahead and get finished with the garage. I'll get back to the deed. You end up having a garage that you paid for to have built that you get no reimbursement for because you could not reasonably rely upon the deed because now you know that you can't get that deed registered. So it's no longer a reasonable reliance. So that my finding here as I listen to this is that there is some reasonable reliance based upon the trust that Mr. Rogers had given the deed, and that in fact it was a good deed. There was some reliance that was reasonable, and that probably over the period of time that is expired between the parties, that some of the reliance was not reasonable. My determination in this matter is that I'm going to split the difference in that regard, where it's $2,300. Then the court will determine that $1,150 will be awarded as reimbursement. So the total amount of the judgment in this matter will be, one moment, $2,850 plus court costs in this matter. Do you recall what your filing fee was in this matter, Mr. Skipper?
Yes, sir. It was $83.
All right. And did you pay a service fee or two? I see a service fee of $13. I see that.
Yes, sir.
All right. So that's going to be the judgment, $2,850 plus the roughly $101 for filing and service fee in this matter, for a total looks like a total of $2,952 or so, and you'll get a copy of that in the.
Could I say something? There's one thing that wasn't correct.
Go ahead, sir.
Can you hear me okay?
Yes, I'm hearing you, Mr. Rogers.
Okay, the 1,700 was the fence that I put up. That was part of, because he came to me wanting to buy the property, but I told him that I had already had 700 in the fence. He didn't put a fence up. I put the fence up and had that in the price of what I sold him the lot for. So he didn't do anything else there other than put those illegal containers, commercial containers on the property. He didn't spend any money on a gate. Matter of fact, the gate of his house that he owned, I actually fixed that gate where I spent $700 putting the fence up. And part of that, he was giving me that back out of that 1,700 because I did the labor and the material costs, and he didn't spend any other money on that lot. He put those containers on there, not, like you said, not knowing if or not he could do anything with it legally. But
Your Honor, if I may interrupt.
No. Well, you don't have to. Let me stop you, Joe. I've already heard the testimony. And I made my conclusions based upon that testimony. I heard Mr. Rogers the first time when he told me about some building of the fence being involved in the pricing and what have you. And I've heard Mr. Skipper's testimony regarding what he did and what he expended for the property. And I've drawn the conclusions from that. I've taken all of that into consideration. And so the judgment is as I indicated, based upon the testimony that I've heard from the parties today. And again, you'll receive a copy of my order. I wish both sides well. Thank you.
Thank you, Your Honor.
Thank you.